Relford.
Thank you, Madam Chair and members of the committee. I'm Guy Relford. I'm the founder and CEO of the 2A project here in Indiana. I'm a certified firearms instructor. I'm author of the book, Gun Safety and Cleaning for Dummies. I'm a certified firearms instructor for Tactical Firearms Training LLC, and I have a radio show on WIBC where we discuss Second Amendment issues. You know, in a lot of different capacities and in a lot of different forums, I've been saying for several decades that a license or a permit is simply the process by which the government sells back to you a right you already had. And in this case, not only are we dealing with a right protected by the Second Amendment, but we're dealing with a right guaranteed in the Indiana Constitution that is elegant in its simplicity. Article 1, Section 32 of the Indiana Constitution says the people shall have the right to bear arms for the defense of themselves and the state. It's very few words, but it means so much. It means we have a fundamental, basic human right to defend ourselves and can bear arms. Bear obviously means carry in the process. That's the right guaranteed to us, not only by the Bill of Rights, but by our own Indiana Constitution. And when I hear so much of the opposition here this afternoon and this evening, it seems to me that it somehow gets misplaced or forgotten that we're dealing with a constitutionally protected freedom. We're not talking about a privilege that's granted to us by the state. We're talking about a freedom that's guaranteed to us, not granted to us. Our basic human rights don't come from government, but in this case, they're protected by both the US and the Indiana Constitutions. And when you think about some of the other basic protections we have in our criminal justice system, here you can see that the licensing system that we've had for so long here in Indiana really turns some basic concepts on their ear. For instance, all citizens are invested by law with a presumption of innocence. And to prove a crime, a prosecutor, the state, in this case of Indiana, has to prove guilt beyond a reasonable doubt. There's a burden to even effect an arrest. There's a requirement of probable cause. But here we have a constitutionally protected freedom guaranteed to us by the US and state constitutions, and Indiana residents have to prove their innocence. They have to prove their eligibility to be able to exercise a basic human freedom guaranteed by our constitutions. We have to go in and prove our eligibility to the satisfaction of government employees, then determine whether we're eligible to exercise a right we already had. The reason 16 states, and I hope soon 17, have enacted lawful carry or constitutional carry is because they've realized through their legislators that that's a concept. It is a repugnant concept that innocent, law-abiding citizens have to prove their eligibility to exercise a constitutionally protected freedom. And as Sheriff Roush said very eloquently, and I won't repeat his testimony, it's all late and folks want to get home, but he stated very, very well that what other freedom, what other right, what other constitutional freedom do we have to prove our eligibility for? Do we have to pass a background check to prove, hey, I'm someone who is eligible to exercise this constitutional freedom? It's just the exact opposite of how we ought to function. If the state can prove we've relinquished our right, so be it. If the state can prove we're guilty of a crime because of something we've done with a firearm, so be it. That happens to me, put me in jail. That's how our system works. But I shouldn't be a criminal because I've not yet proven my eligibility to exercise a freedom guaranteed to me by the constitutions. And so many times we see the analogies to things like driving, or even something like being prosecuted for OWI. I find that repugnant because we're talking about a constitutionally protected freedom, not a privilege. but something guaranteed to us. And the justification often is the idea that, and this is a quote I've heard more than once this evening, that we need to keep guns out of the hands of dangerous criminals. Someone who will tell you that a licensing system, quote, keeps guns out of the hands of violent criminals is asking you to believe this premise. That, for instance, if I'm a drug dealer at 30th and Sherman, and I've decided to murder my rival drug dealer, someone competing with me for territory, and I'm not afraid of the death penalty, I'm not afraid of 60 years in prison, I'm not afraid of whatever the state chooses to do with me for committing the very violent crime of murder, that doesn't cause me any concern. I'm not afraid of 60 years in prison. But on the way to commit that murder, I'm going to stop and say, hold on, I better not take a gun with me, particularly a handgun, because I could be prosecuted for a Class A misdemeanor, their current penalty for carrying a handgun without a license. Is any criminal, any violent criminal, going to be deterred? And even with the elevated forms of carrying a handgun without a license, for instance, if you've had a felony conviction in the previous 15 years, or if you're carrying a handgun without a license within 1,000 feet of school property, those become felonies, but only a level 5 or a level 6. So if I'm not afraid of murder or the death penalty or 60 years in prison, why on earth would I be deterred in any way by a Class A misdemeanor or by a level 6 felony? That doesn't bear up to any scrutiny, it's not logical, and it doesn't happen in the real world, because a law enforcement officer who was asked tonight, or this afternoon, do violent criminals still carry guns despite not having a license, every one of them admittedly, said yes. And they have to say yes because that's what we all observe. So I emphatically support House Bill 1369. I thank not only Chairman Smaltz and co-authors, Representative Lehman, for their efforts on this bill, but it's built on a long foundation and a lot of work put in by a lot of people, including Representative Lucas, who's worked very, very hard on this issue. So I thank you all for the opportunity, and we'll be glad to answer any questions.
Thank you, Mr. Relford. Questions? Representative Lucas?
Thank you, Madam Chair. I think this is a very important point to make, Mr. Relford, and I think it's critical that everybody understands this. Could you briefly describe the Pinner decision?
Yes, and one of the officers went into it a little bit, but the importance of the Pinner decision is there had been a long debate between, to some degree, gun rights advocates and law enforcement or prosecutors. If law enforcement observed someone with a handgun, or if there was a report of someone with a handgun, does the officer have the right to stop that person and investigate them and initiate what we call a Terry stop, after Terry v. Ohio, the 1968 case that allowed, in some circumstances, the stop and frisk on the street? And the standard for a detention, so as to investigate someone and see if they're engaged in criminal activity, is a reasonable, articulable suspicion of criminal activity. And as related earlier, the Pinner case involved a person who, as he's getting out of a taxi, dropped a handgun. And he quickly picked it up and put it back in his pocket. So the cab driver called 911 and said, hey, a guy getting out of my taxi just dropped a gun. That's all he said. He just had a gun. So IMPD rolled in. This is at the theater roughly at 86 and Michigan. IMPD rolled in. They detained him, and they investigated whether his possession of that gun was lawful or not. It turned out it was unlawful, but the question became, did they have that reasonable suspicion of criminal activity so as to detain him and investigate? And our Supreme Court in 2017, in their decision, wrote a really, I think, a beautiful opinion and one very well reasoned, which is they said, hold on, law-abiding citizens carry guns too. If all you have is a report of someone in possession of a gun and no further evidence to suggest that activity was illegal, either possession of the gun or something he was going to do with that gun, then that's no basis for a reasonable suspicion of criminal activity. You may not detain that person, just as we don't allow officers to randomly pull over drivers to check for driver's licenses. So it says law-abiding citizens carry guns too, and we're to be treated as law-abiding citizens. until law officers have some basis to believe that we're not. So when I hear law enforcement officers today say, well, I see someone with a gun, I need to know whether that's lawful. No, you need to know that that's a constitutionally protected freedom, and unless you have probable cause or a reasonable suspicion that they're doing something illegal with that gun, you bid them adieu and send them on their way. That's a requirement of our Indiana Constitution.
A brief follow-up. Correct me if I'm wrong. Was that not a unanimous decision?
It was by the Supreme Court.
Okay, so we have, in effect, a unanimous de facto acknowledgement by the Indiana Supreme Court that we have a right to carry a handgun.
That's exactly right. And it follows on the heels of a 2010 opinion by the Court of Appeals in the Melvin Washington v. State case. Very similar. He was pulled over for something very minor, for having his headlight out. He disclosed that there was a gun in the car. The officer then insisted on searching the vehicle so as to find that gun, to seize that gun for officer safety. And the Court of Appeals said, hold on. All you had was knowledge that he had a gun. In this case, he had a license to carry. But all you had was knowledge of the possession of a gun. That doesn't create a reasonable suspicion of criminal activity or dangerousness to the officer because, again, law-abiding citizens carry guns too. And we're to treat law-abiding citizens as law-abiding citizens until there's probable cause or reasonable suspicion to believe that they're not. That's been around since 2010. The Pinner case put a beautiful point on it. But that's where we are. That's how we should be treated. And that's what House Bill 1369 would put us back to.
One last question, Madam Chair.
I will indulge you one last time.
Thank you so much. Mr. Relford, we've heard repeatedly people being denied their license. Have you represented people that have been denied and got their license for them?
Oh yeah, dozens and dozens and dozens. I saw Lieutenant Pete Wood, who is an attorney with the state police, who is leadership in the firearms licensing division. I work with him regularly, and I've had dozens and dozens and dozens. I'm sure probably 100 where people have been denied, and I'm whatever the number is and one. Because one time I did not get a license issued. I still disagreed ultimately with the decision, but in every other one we've got it. And by the way, that's not a criticism of the state police. I think they do a fabulous job. And we talk about delays during COVID. It's not from lack of hard work. I was getting emails from these people at 3 a.m. and they're working from home during COVID. I mean, they were really busting it and being heroic in my mind. So no delays are due to anything relating to lack of hard work. But it's not their fault because a lot of times the criminal history they see is perhaps incomplete, that someone had a felony, but then it was later reduced to a misdemeanor. They didn't see that in the record. We correct that, we get the license issue. But some of the testimony that, well, there's a process and it's no problem and they get their license is not free, especially if they have to hire a lawyer. And there can be a long delay involved and there's legal fees involved. And it's a burden I don't think that law-abiding citizens should have to be put through.
Other questions? I have one myself. There was earlier testimony that this bill lacked the provisions for the surrender of firearms, but that is addressed elsewhere in statute. That was a concern of one of the folks who testified, is that there's no provision for a surrender of a firearm if you should be found not be a proper person. That isn't addressed in this bill, but that is addressed in Indiana code already, isn't it?
Well, we certainly have what's become known as our flag law, which allows for the seizure of firearms from people who are determined to be dangerous to themselves or others. That seizure is there. And then obviously if someone's arrested for any crime, including possession of a gun by a prohibited possessor, as is created in this bill, they're obviously separated from their firearm and they're arrested.
And under certain protective orders as well, that someone has to sacrifice.
Madam Chair, I'm glad you said that. Yeah, that there is a requirement or a provision in Indiana law that an order of protection can require the relinquishment of firearms and ammunition by someone subject to that court order.
Okay, thanks for clarifying that. Mm-hmm. Any other questions? All right, thank you, Mr.
Thank you,
Relford.
Madam Chair, members of the committee.
That